Good morning, my lady.
Yes.
Wonder why my camera is not switching on. Can her ladyship see?
No, I can't see anybody actually.
Really? My camera is on. My mic is on.
I can hear you. In fact, I can't see anyone.
Strange.
She can see you.
How should we proceed, my lady? May I put myself and Junior on record, if I may?
Yes. For
may
the
please, my lady, may it please you, my lady. My name is Advocate Lindy Nkosi Thomas, SC, a member of the Johannesburg Bar. I appear together with my learned friend, Miss Ntuli, on behalf of the SIU. May it please you, my lady.
That's Advocate Ntuli, right?
It's Nkosi Thomas with
Advocate Ntuli.
That's right.
Good. Thank you, Ms. Nkosi Thomas, for the respondents.
Morning, my lady. May it please your ladyship, I appear with Miss Lani. Oldwage is my surname, spelled Oldwadge, and we appear for the first respondent.
With Miss Lani, you say?
Lani, indeed, my lady.
Mr. Oldwage, you are SC, right?
No, I'm not.
Not, okay. With Advocate Lani. Thank you. Okay, I can see you and your junior, but I don't see Miss Nkosi Thomas, so there might be a problem with her camera, but hopefully she'll fix it shortly. Right, Miss Nkosi Thomas, how are we proceeding with this matter today?
May it please you, my lady, our learned friends have brought an application for a stay of these proceedings. And we have filed a notice in terms of Rule 10, Sub-Rule 4 of the rules of this Honorable Tribunal. In other words, we're raising certain points of law in regard thereto. May I propose perhaps that our learned friends should address her ladyship in regard to the stay application, and we shall respond accordingly. May it please you, my lady.
Yes, thank you, Mr. Oldridge.
Thank you, my lady. Perhaps it's not necessary, albeit that I have a short chronology of what has transpired and what has resulted in this application for a stay having been launched. And if necessary, I'll provide that in due course. However, I do believe what is necessary for me to place on record is that we received the applicant's Rule 10 for notice. It was served this morning in the early hours of this morning. I might as well at the outset submit that Ms. Lani is dealing and seized with the application, and she has advised that she's considered the Rule 10 for notice, and whilst certain aspects of it are capable of being readily answered and dealt with, there are constitutional issues that are raised, which obviously necessitates a response from us in relation thereto. We have commenced with, but certainly have not concluded, what we are preparing in the form of submissions in relation to how we will respond to the 10-4 notice, bearing in mind that it was only served this morning. There is, should it become a necessity for me to deal with what transpired in relation to this application, I don't think it's been contended for that the application was brought late. The application, albeit that I wasn't involved with drafting it, makes reference to when it came to our attention that there was a postponement granted, which is not exclusively, but certainly some reliance is placed on that for purposes of seeking a stay in this matter. I will deal with that chronology if required. My learned friend hasn't taken issue with that, and perhaps she doesn't, but should she, then I will obviously deal with that short chronology. The position, my lady, is, and it is regrettable, that we're not able to proceed with the submissions presently. We do require an opportunity to obviously consider some of these aspects raised in the 10-4 notice carefully, and to provide our response thereto as it pertains to these legal issues. My learned friend, Ms. Lani, indicates that there's a necessity for us to consider certain case law, and we will seek an indulgence from your ladyship. I might as well, and I'm not at all being prescriptive in this regard, indicate that I know that this is not a running role, but Ms. Lani tells me that she's able, so as to avoid an unnecessary delay, she would be able to proceed with arguing this application, my lady, subject to your ladyship's availability still in this week. We're already on Wednesday.
Yes. Unfortunately, I have already a matter on Friday, so that might be a bit of a problem. Next week, I'm available that last few days of August. Next week, I'm back in the High Court with a partly heard matter. And then the Monday thereafter, which I think might be about the 29th or so of August. I'm free those 3 days, 29, 30, 31.
My lady, might I, and I know this is just provisional, might I just inquire? I have a pretty busy diary. Miss Lani is going to deal with this application and will in fact argue it before you. It won't be necessary for me to be in attendance on that day. I'm obviously seized with arguing what I would term to be the main application. So Ms. Lani indicates to me, so if I may be excused for those purposes.
Well, it obviously depends entirely on Ms. Nkosi Thomas's availability. I haven't given her a chance yet. Just based on what you are going to say now, she will obviously respond in respect of this. And the gist of it is that there are issues raised in the 10-4 notice, which you need to consider and reply to. I'm not sure whether the notice needs to be supplemented by the SIU. Ms. Nkosi Thomas will tell me now, whether there's because of the time constraints. I mean, I received this after lunch yesterday, your application for stay, and understandably they had very, very shortened time periods in which to file their notice. I'm just going to hear from her. What is it that she sees as the way forward from the SIU's point of view? And
as you please.
She would have heard now that my availability, and she could possibly address me on that as well.
Thank you, my lady.
Is there any further submissions you wish to make, Mr. Oldway?
Thank you, my lady. I have none at this point. Thank you.
Thank you. Ms. Nkosi Thomas?
May it please you, my lady, the predicament that we all find ourselves in is certainly self-created by the respondents. And with respect, they deserve no sympathy from this court. The constitutional court matter relied upon was argued in May already. They wait, my lady, until yesterday, 1:30, to bring a stay application. And they make us burn the midnight oil, filing a Rule 10-4 notice this morning, only to come here and say, no, sorry, we're not ready. So that is unacceptable in the extreme. We view that as an abuse of the court process. We view that as a delaying tactic that should not be countenanced, my lady, by this court. But be that as it may, that's the first point that we wish to put on record, my lady. A further point that we wish to place on record is that your ladyship sits as a member of this special tribunal, and your ladyship would be aware, no doubt, of the jurisprudence that suggests that this is is a special tribunal which was created with a view to affording the SIU a speedy remedy. Now, this matter has been dragging on for a long time. It cries out for expeditious resolution. But having said that, one does appreciate that perhaps our learned friends should be afforded an opportunity to carefully consider the issues that arise in this matter. I must also mention that her ladyship would have seen that this matter turns on common cause facts. There are no genuine disputes of fact that really warrant a further delay of the matter. But be that as it may, in regard to the stay, we've had your ladyship's availability during the week of the 29th and the 31st. In the way of a suggested way forward that her ladyship has invited us to make, we suggest that this matter should be heard on the 29th and the 31st. And on that occasion, my lady, what we propose should be heard. On the 29th, we argue the stay, and if her ladyship could rule with respect without stampeding her ladyship on the 29th, one way or the other, and then we return. If her ladyship is with us in refusing the stay, then we suggest that we recommend that we return on the 31st to argue the merits, my lady, so as to accommodate both parties. That would accommodate our learned friends in getting the stay application argued, and it would accommodate also the SIU in getting their day before this tribunal as expeditiously as possible, my lady.
So you say the stay application to be heard on the 29th, and then I give a ruling, and then you argue the main application on the 31st. That is, do I understand that to be your proposal?
Yes, please, my lady. The stay, we will assist her ladyship best we can, so as to place her ladyship in a position to rule on it as expeditiously as possible.
All right. What I would need, and I think would help is we could use next week. Sorry, before I go on, Ms. Nkosi Thomas, do you see your way forward to supplementing your Rule 10 notice?
No. What we will do, my lady, in order to assist this tribunal would be to file brief written submissions for the assistance of the tribunal.
Yes, which is what I was going to propose that both of you do during the course of next week, to give me an opportunity to consider it, possibly by I don't know if you have timeframes in mind, so that it gives me a chance to also consider it before Monday and consider it properly, not on the morning of the 29th, so.
Yes, our learned friends, being the dominus litis in the stay application, should probably file their written submissions. Today is the 17th, say by the 22nd, Monday the 22nd, and we would file our rebuttal submissions on Thursday the 25th, and then the matter would then be argued on the 29th. Those are suggestions.
As long as we can keep to those dates. It does constrain me if, people don't adhere to dates, because then it puts me on the back foot in that I don't have sufficient time to read and consider, because these are weighty issues which need to be considered. Mr. Aldridge, what do you say about those timeframes?
My lady, very briefly, and I don't wish to burden this record, I need to respond to this submission that this is an absolute abuse. I'm not going to drag it out, so to speak. My submission is simply this: there's no abuse. The position is, as your ladyship has already indicated, this is an application worthy of consideration. Weighty issues have been raised, and that alone makes nonsense of any suggestion that this is an abuse of process. But be that as it may, I'm not available on the 29th. But Ms. Lani is available, and she will proceed, if so required, with the application on that date. I will be available on the 31st, my lady, to proceed with the main application, and we're in agreement and amenable to what has been suggested as being the dates allocated for the filing of further process. My lady, just one further aspect, and it is necessary for me to place this on record. Your ladyship will notice from our heads of argument that the SIU has been dilatory, I put it no higher than that, in responding to and complying with guidelines and directives issued in terms of the case management meetings which we attended. I implore them this time to stick to those deadlines and to comply with those directives. Thank you, my lady.
All right then. Yes, it does appear that both parties need to address the issues that have been raised, both in the papers, which were prepared at very short notice, as well as what has arisen today. The dates that have been proposed for next week in order for the parties to file their submissions, which I take it would also be in the form of heads. Your submissions would be in the form or would serve the purpose also of heads. The 22nd of August, 2022 for the applicant stroke respondents to file their submissions, and the 25th of August, that is the Thursday, the 25th of August, for the applicant respondent, that is, the respondent applicant, which is the SIU, to file their rebuttals and their submissions. Then the matter will, the stay application will then be heard on the 29th of August. It's Monday, the 29th of August, 2022. And the 31st of August is reserved for the hearing of the main application, the main review application, obviously depending on what the court rules after the hearing on the 29th of August. So if that is suitable to all parties, then it will be so ordered. I will forward the order in writing to the registrar of the tribunal, and she will then disseminate that to all of you. Then just one thing is the question of costs will stand over. Ms. Nkosi Thomas, does that suit you? Are you in agreement with that?
Indeed, so, my lady. May it please your ladyship.
Good, thank you. Then it is so ordered. Just to repeat then, the stay application is postponed to the 29th of August, 2022. The main application, that is the review application, to the 31st of August, 2022. The applicants, that is BEADICA, is to file its submission stroke heads on the 22nd of August 2022, and the reply rebuttals by the SIU to be filed on the 25th of August 2022. Costs to stand over. Right, that is anything that you wish to add, or is there anything I've left out?
No, none, we have nothing to add from our
Good.
side.
Then thank you. I think then all that is left to say is that court adjourns.
May it please you, my lady.
Thank you.
As your ladyship pleases, thank you.